This is a challenge to all the judges and magistrates out there regarding mediation. The Divorce Act, the Maintenance Act, the Children's Act, High Court Rule 41A all stipulates that civil matters must be handled through mediation. Civil matters, correct me if I'm wrong, also include family-related matters. The laws already exist around mediation. We know that in the 70s, the 80s, and the early 2000s that mediation was strongly suggested during the process. Now, we do understand that the Family Advocate's Office has a mediation role and does act or does perform a mediation role. That's great, that's fantastic. It needs to be strengthened 1,000,000,000%. We do know that in the 70s, 80s, and early 2000s that the suggestion was made that the process of mediation needs to follow, well, not in the 70s and 80s, but definitely in the 2000s, that the mediation process should follow the same line as was originally intended, the same way the CCMA and the Labour Court works. Fathers for Justice is absolutely clear that the court system in its current guise does require a loser and a winner. And that is the fundamental flaw within the family law system. In the absence of, and I've got to use other words, please excuse me, but in the absence of a bus E and other irregular conduct, there's no compelling reason. So in the absence of a bus E, you should be giving nothing less than 50-50 contact care, guardianship and maintenance. Fathers for Justice is driving that. We are engaging the Department of Social Development. We have been engaging the Department of Social Development over the last 5.5, 6 years in regards to this, and we are not going to let up on that matter. However, judges and magistrates' courts are unnecessarily clogged up with family-related matters. You have the power as judges and magistrates to reduce the unnecessary waste of court time and the waste of taxpayers' money and the clogging up of your courts on a simple matter. When it comes to divorce, mediate. There are specific laws in place, and there should be some form of prenuptial agreement. And as you all know, if there's no prenup, it's done in community of property, and you divide the assets accordingly, the assets and the debts accordingly. Our challenge as Fathers for Justice is to judges and magistrates across South Africa. It is within your power to demand that mediation take place, and for that instruction to be given to lawyers and or their clients and or the family clerks of the courts, etc. You have it within your power to demand that mediation takes place. I do understand that mediation must be voluntary. That is why we will be responding to the Law Reform Commission's request for comment on mediation, where we are saying specifically that mediation must be mandatory, and because the process or protocol around mediation must be voluntary, we are saying use an alternative word. In this instance, alternative dispute resolution. We are talking to the Department of Social Development to make 50-50 contact care, guardianship and maintenance in the absence of a bus E and other irregularities. Okay? That 50-50 contact care, guardianship and maintenance is mandatory. So what are you going to go and do during the alternative dispute resolution? You're going to discuss logistics and you're going to discuss finances. And we are challenging the judges and magistrates in South Africa to start forcing the process. It is within your ambit of influence. you can do this. And we are saying it is completely unnecessary that this unnecessary conflict is taking place at an exorbitant amount of cost. And I do know that you're going to turn around and say everybody's entitled for their day in court. Court is not the place to be handling family-related matters, no matter whether I'm entitled to do it. If you follow the labor court process, CCMA, arbitration, yes, we know that arbitration is expensive, but that's the whole point. And failing which, only then can you either approach the family court or the children's court, etc. But when you are going to family court or children's court or high court, you are going to discuss one or two topics, because what we have proposed is that where there's been resolution, for instance, there's 10 items on the table, it should go to arbitration. If the parents frustrate the process or are unable to come to a conclusion. But what we're saying is, you've got 10 points on the table, you've managed to resolve 8, those must become automatically binding, given that it is 50-50 contact, care, guardianship and maintenance. The other 2 points that are in dispute, that goes to arbitration, which is final and binding, obviously from an arbitration point of view, but then if there's still an issue, then those 1 or 2 issues are only allowed to go to court. We are demanding that from date of separation to finalization of alternative dispute resolution, that it shouldn't take longer than 90 days from date of separation to do the mediation, have it endorsed by the Family Advocate's Office and signed off by the Magisterial Court, or the Family Court, sorry. So we are challenging judges and magistrates out there. Why are you, ladies and gents, allowing your courts to be clogged up with issues that already is in Divorce Act, Maintenance Act, Children's Act, High Court Rule 41A, demanding that all civil cases be mediated? Why are you not enforcing it? And we're not interested in that excuse that everybody's entitled to their day in court. That misses the point entirely. If one or both of those parents did not see, is specifically around the raising of children, raising that child with that parent, that's their problem. That parent knew that the mother was an alcoholic. That parent knew that the father had a gambling problem before they had a relationship and had a children out of it, irrespective of marital status or not. So we are challenging you, please. This unnecessary conflict, the average, we have worked out that the average court case is taking anything between 5 to 8 years at a cost of anything upwards of 1 to 5 million rand. What percentage of the population can afford that? The vast majority just walk away. Then we have issues around maintenance. Please see the last video that we put up on maintenance. Our challenge is to the magistrates and the judges of South Africa that you force the mediation process, and we would love to engage you directly. So please, can somebody contact me? I have written to the Department of Justice and the Family Advocate's Office and the State President and the Law Reform Commission and Centre for Gender Equality, Public Prosecutor, Public Protector. The bottom line is that you have it within the ambit of your power to start forcing mediation, and we are saying we agree with mediation. We are going to be responding to the request for comment by the Law Reform Commission on mediation, specifically related around family-related matters and divorce. We're not interested in the other stuff. We are specifically focusing on family-related issues and divorce. If there's anybody else there having issues around mediation, if there's anybody that requires litigation because the other party has abandoned and or frustrated the mediation process, please, there's the email, there's the website. Please reach out to us. Let's get the process going so that we can start assisting you. I love you all.